This high school boys volleyball coach is accused of having sex with one of her teenage players multiple times. She's now facing multiple sex crimes charges, and according to police, she told them initially there was nothing going on. But I'll tell you the shocking text messages police say they found on her alleged victim's phone and how police say a wallet brought this disturbing case to light. We're on the case presented by Law&Crime. I'm Chris Stewart. If you played a sport in high school, then you know that the relationship with your coach can be really important. It can matter a lot more than just wins and losses, and it's the type of relationship that can become a bond that can last a lifetime. High school coaches are that important. I want you to meet Coach Brooke Reinhardt. She is the boys volleyball coach at Burnsville High School, which is outside of Minneapolis. Her name is listed on the school's official page, as you can see here, as the coach of the boys volleyball team. Police say she violated that position of power that I was just talking about, that one that carries so much trust of being a high school coach. Police say she had sex multiple times with one of her own players. This is her mugshot that was obtained by KTSP TV in Minnesota. I also have the criminal complaint that lays out the narrative that police have of how this coach allegedly had a sexual relationship with someone who was on her own roster. Police say they first learned of allegations against Coach Reinhardt on July 1st of this year. So this was very recent. A man who is only identified as witness one says the coach was looking after his home while he was out of town the week prior. Now it's unclear what his relationship is to Brooke Reinhardt. The criminal complaint says when witness one returned home, he found a wallet in his home. And that wallet belonged to one of Coach Reinhardt's players at Burnsville High School. That player was 17 years old. Now, according to police, there was no reason for that teenager to be at the witness's house. Witness one says that he called Reinhardt and she really brushed it off, it appears, saying only, quote, okay and okay, bye. But witness one apparently knew something may be up and was concerned, so he called police. Police wrote when they interviewed the teenager who the wallet belonged to, he said that Coach Reinhardt gave him a lift to practice a few days prior to June 28th, and he must have left the wallet in her car. Police say the victim also spoke highly of his coach, saying that she was really nice and they had an athlete-coach relationship. That's it. He also went on to say that they did not spend time together aside from their sport. The teenager did say that Reinhardt sent him a text letting him know that he had left his wallet in her car. And that appears to be the door that officers walked through and got to checking the teenager's text messages to see what the communication was like with his coach. And this is what they found. According to police, they found text messages from Coach Reinhardt to the teenager telling him, quote, he had a lot of things to delete. There were also text messages about condoms between the two, police say. Before we get back to this episode of On the Case, I want to bring you a Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And research is potentially linking ultra-processed foods to these outcomes. Our partners at Morgan & Morgan are stepping in to fight to hold food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or non-alcoholic fatty liver disease, go to www.forthepeople.com/food. You can also scan this QR code on your screen or click the link below. Now it seems at this point, this teenage victim then opens up about what allegedly was going on with his volleyball coach. The teenager said over the past 2 or 3 months, Coach Reinhardt tried to help the teen with his social situation. At first, he said they would go out to eat, but then he claims things went further and they started kissing, and that led to what he referred to as dating his coach. But it doesn't end there. The teen said that initially it was just kissing, but then he said his coach had sex with him. The first time was reportedly in May at Coach Reinhardt's house. Then a month later, allegedly at the house where the man found the wallet of the teenager and alerted police. The teenager said that they built a Lego set and watched TV at witness one's house. Then police asked about the text messages related to condoms, and that's when he said he had sex with his coach. Now, Coach Reinhardt also allegedly sent nude photographs of herself to the teenager. Police then arrested Coach Brooke Reinhardt on July 2nd, just a day after police first learned of the allegations against her. Now, police say during an interview that she told them at first it was the same story that they heard from the victim in this case, which was that the teen had left a wallet in her car, they had a player-coach relationship, and that was it. Nothing more. But then Coach Reinhardt's story apparently unraveled. The coach reportedly told police in May of this year that she engaged in sex acts with the player in her vehicle, and that included digital penetration and oral sex. She told police that she had sex with her player 3 times, once at her house, once at his house, and once at the house where that wallet was found. She also allegedly admitted to sending nude pictures in the shower. The story of a high school coach accused of having sex with a player felt very similar to a story that we've been following here at Law&Crime out of Chicago.
You Christina?
Yes.
Okay, Christina, do me a favor. Can you step out of the car for me?
This is the body cam video of Downers Grove, Illinois teacher and soccer coach Christina Formella getting arrested in March. In her case, she's accused of having sexual contact with a boy that she coached in soccer starting when he was 14 years old. She's now facing more than 52 charges in that case. She's pleaded not guilty. For as many similarities as we saw between these two cases, in the case involving Coach Reinhardt, there are some differences. In her case, she's facing 3 counts of criminal sexual conduct. Each charge carries up to 15 years in prison and up to a $30,000 fine. Joining us now to talk more about this case from St. Paul, Minnesota is criminal defense attorney, former prosecutor, and retired CIA agent Jack Rice. Thank you for taking the time to be with us on Law&Crime. I know this story is taking place not far from where you live. What are some of the things that stand out to you thus far?
Well, when we look at a case like this, there's a couple of things that I'm looking at. I mean, you have to look at the concept of the criminal sexual conduct. Essentially, this is akin to statutory rape, but it's a little bit different than that. And the reason is that in Minnesota, technically, that age, that magic age, is 16. The complaining witness, the victim in this case, is 17 years old. But what makes it different is that because she's his coach in school, that puts her in what's called a position of authority. That changes it. That means that age bumps up, and that's what really provides that criminal exposure.
In looking at the criminal complaint as well, I saw it noted that she was more than 36 months older than the alleged victim in this case. Typically in Minnesota, how does that factor into, like what you're saying here, even if the age of consent is 16, she's in a position of power and much older than he is?
Right. When we're talking about cases like these, so we're always talking about the age of consent in the first place. If you're under that age, under 16 years old, that consent issue is lacking, if you will. You get over that age, then it changes, unless you're in a position of authority. And what that really means is that it's about the concept of coercion. What happens when you're in a position of power over somebody else who's a juvenile? And I mean 16, 17 years old, and you have the ability to coerce them in some way. So this would apply to police officers, firefighters, teachers, lawyers, doctors, et cetera, those in a position to actually drive them to make decisions that they might not otherwise make. That's the reason we're looking at a case like this. And of course, what does make this unique is that we usually, when you see cases like these, it's usually men on girls, men on juvenile boys, not the other way around.
Right, and even writing this story, in writing Coach Reinhardt, and when you think of that word coach, and then you see her picture, it's not, and look, I mean, it's just the reality for a lot of people. I mean, that's just the way that you think about in these cases, that you don't see the dynamics like this. You've seen both sides of it, as well as a former prosecutor, now a criminal defense attorney. If this were to go to trial, and she's admitted to a lot, so I don't know, and we can talk about how this could be prosecuted going forward, but how could that dynamic play out in court?
Well, it actually can. I mean, you're right. She's admitted to a lot already, and we don't know what's admissible, what's not admissible. And this city where she was actually a coach, this isn't a county that I operate all the time. I've had cases like these. I've gone to trial in cases like these. So I think about that issue. But if we think about what it is that is somebody in this position, and you're right, you think Coach Reinhardt, what's the first thing that comes to mind? Sort of this creepy dude going
Yeah.
after juveniles. You see this picture of this young woman. Frankly, she doesn't look much older than the alleged victim. And when we think about that, you actually have that potential advantage in a jury trial to say, was this really a, we'll use that term, statutory rape? Was this really that? Legally, yes, but you have the ability sometimes to have some jurors say, you know what? I don't think so. So it's not as simple as it may appear to be.
And from her standpoint, the criminal complaint said that she was read her Miranda rights, and she admitted to having sex with her player 3 times and sending nude photographs to that player as well. As from the criminal defense standpoint, I mean, how do you take on this case knowing that police have this interview? It's recorded. She read her rights, and it appears, and maybe it was just the guilt, the shame of the moment. She's admitted to everything. What do you do?
Yeah, this is absolutely one of those issues. And there are times when you have cases like these, you're trying to find resolution. What's the answer in a case like this? And what will happen is the prosecutors, while they don't have to listen to, quote unquote, a victim in a case like this, that may very much play a role in how something like this plays out. And I think this is all about mitigation at this point. When you have somebody who's admitted when they actually have the Miranda rights read to them, the likelihood of admissibility, sure, you can contest the admissions that she made to those officers, whether or not you could exclude those, that may change something. There's always a question on whether or not you have the cooperation of a complaining witness or anybody else, whether or not they did everything right when it comes to search warrants of those phones, those other computer devices. I mean, those are all issues. You got to remember, there's always 2 fights in every trial. There's that first fight, which is about admissibility, about what comes in. Then there's the second fight. So we don't necessarily know what's really going on here. However, based upon what we're seeing right now, I think this is the kind of case that you really work toward mitigation, toward a plea agreement, trying to find ways to avoid prison if possible, because this comes with a presumptive prison commit.
Yeah, I'm interested to get your thoughts on that too. I know each count, according to the complaint, was up to 15 years in prison, and what that could look like knowing this county and how they typically do these cases. But I also want to bring up, and this isn't the argument that I'm making, but I've seen the comments online, because you have a person here, a male, he's 17 years old, he'll be 18 next year. And again, I'm not saying this, but I'm speaking from just what I've seen online. And you're a former prosecutor, so you've prosecuted cases like this, and you know sex crimes. There are people who will look at this, and yes, she's a coach, but say, what's the big deal? Does she deserve to go to prison for this, become a sex offender because of what she's accused of?
Yeah, I think that is exactly the argument that the defense would make here. And more importantly, the complaining witness in this case may very well make that argument. They may actually say, I don't want her to be convicted of this. I don't want her to be a registered sex offender. Here's one of the problems, though, in Minnesota. It's extraordinarily aggressive when it comes to that sexual predator registration requirement. So in other words, if she admits to this, even if she weren't found guilty of it, she would still be required to register as a sexual predator for the next 10 years. So this is going to sink her almost certainly on that issue alone, let alone the criminal piece. But there are sometimes ways around the criminal side of this, but you're still walking around with that predator registration wrapped around your neck.
Right. And I think too, if you're the prosecution, you're going into this, and even if the public would look at this, and I don't know, it depends on the jury you get, if it goes to trial, and but if there is this idea from the public of like, well, he was 17, and all of this, again, I'm not arguing that, but as a prosecutor, what's your pushback against that if the defense is going to say that this really isn't as big a deal that she should be a sex offender forever?
Yeah. Do you want your teachers to be able to exploit, to target, to molest your children? There's my question. Do you think that it's appropriate? Exclude gender from this for a second. Let's push that issue aside. Do we allow our teachers to say, you know what? I know I could teach you math, I could teach you English, I could teach you how to read and write, or I could teach you volleyball. But instead, what we're going to do is sexually assault you. I'm sure we're fine with that. Well, see, nobody would agree to that. And I think what you're going to do, if you're a prosecutor, is you have to really push to try to exclude that gender question, because I have talked to people about this issue, and then I have had people say to me directly, this isn't a crime. I would have been fine with this if I were 17. I've heard it. I'm not suggesting it's correct, but guess what? We have jurors who are human beings too. And all you need is one to say that. You get a hung jury, and the prosecution knows that too. And so with that in mind, you may very well see some sort of a resolution. There's actually ways to avoid a conviction in this case. There are even ways to avoid prison, because this is a presumptive prison commit. The problem is if you get that admission in Minnesota, even for something called a stay of adjudication, where there's no conviction, they could probably, well, not in that case, but almost anything else would result in a registration requirement. It's these two things that wrap around each other that make this kind of work, certainly on the criminal defense side, extraordinarily difficult. And frankly, from a prosecution perspective, this is one of those powerful tools that they use in order to say, we either fix this or you go to prison for a very long time.
In Minnesota, if she were to register as a sex offender, what would come with that?
A lot. In other words, it has to do with where you work, where you live, how close you can be to children, places that you can go. She's done as a teacher forever. Frankly, she's done as a teacher forever now. She will be excluded. She's going to lose her license, I think, without question already, based upon what I'm seeing right now. It's a very long list. They can control her access to computers. They can control her access to phones. They can control where she goes in some ways. This is a very, very deep control that you see. And this is over and above what you can see from a probationary perspective. And remember, even with something like this, with the probation, the nature of sex crimes in Minnesota means even if they executed on time and she went to prison for a very long time, even after that, they can actually extend her probationary period so they can provide even more oversight. This is one of the most aggressive charges, crimes in Minnesota that we see. And frankly, they're harder in some ways to defend than even murder cases because of what they can do and how they do it.
And I think too, is this criminal complaint I was reading through where the victim was it seemed like trying to cover for her in some way, like their stories lined up initially, and then the text messages just kind of opened everything up. But he had said that she was trying to initially help him with his, I guess, some social awkwardness that he had. And like, I could see the prosecutors be like, this is a predator. Like, this is someone who was, the kid was awkward and then she preyed on him. And we'll see if they make that argument. So these charges she's facing, there's 3 of them, and she could face up to 15 years each per charge. It's 0 to 15. What is sentencing potentially? And I know we're getting ahead of ourselves and there's a long way to go, but if she were to be found guilty of all 3, what does sentencing look like?
It's a great question. There are so many answers to this, and it all depends upon those negotiations. So let's go generally. Yeah. The max is 15 years for each count. And she's charged, by the way, with criminal sexual conduct in the 3rd degree. Criminal sexual conduct in the 3rd degree comes with a presumptive 48-month commit to prison. So that's for one count. Now, there's actually something in Minnesota called Hernandizing, where they can stack them on top of each other and give you even more time. So there's potential for even more time than that, even if they wanted to go consecutive sentencing back to back to back, right? So they could do that. Now, that's an option. Now, there may be a possibility here for something called a downward dispositional departure. I know I'm getting in the weeds here, but certainly for your viewers who are watching how Absolutely. This criminal process works, there's something called a downward dispositional departure. And what that does is that may allow, under some circumstances, that she avoid prison entirely. but she could actually serve up to 364 days in a local jail rather than a state prison. However, even with that, she would still be required to register as a sexual predator. So that comes alongside this, regardless of that issue. This is a crazy part, by the way. Believe it or not, even if she were found guilty of a misdemeanor assault, just a basic assault, even a petty misdemeanor basic assault, anything that allows for an admission and a conviction would require that sexual predator registration requirement in Minnesota. It's one of the things that prosecutors use as extraordinary tools to force convictions. It happens all the time.
How long or what goes into determining how long she would have to register as a sex offender if it gets to that point?
Actually, it's very specific, and it's the Department of Corrections, which is over and above, separate from this case itself. So depending upon the kind of charge, typically as an example, if this was a sexual assault of somebody under the age of 13, lifetime registration. You get something over that, it's usually a 10-year registration. If you get multiples, then it changes. Now you're talking about level like 1, 2, 3 sexual offenders. That's when it becomes a completely different animal altogether.
And then just lastly, if she was your client and you're meeting with her today, you know what we know from the criminal complaint and what she's admitted under Miranda rights apparently already. I mean, what is that meeting like and what is the strategy that you take?
Boy, honestly, that's a great question. From my perspective, and I've been doing this for almost 30 years. Again, I've tried cases in this county, other counties across the state of Minnesota. I'm what's called a board certified criminal law specialist. Less than 3% of criminal defense attorneys have that. If it were me and she were sitting across from me right now, probably the first thing I would say is take a breath. I know you're scared, and I appreciate, I would be scared if I were you too. But at the same time, let's get you in to see some help. Let's get some help for you. Let's have you start seeing a therapist. Let's contemplate potentially a psychosexual evaluation so we can establish how much of a threat you really are. Because sometimes what you want to say is, this was so oddly, strangely unique that you are not a general threat beyond this crazy one-time outlier incident, and try to find ways to say, is there a way to fix this? Is there a way to avoid that registration requirement? Is there a way to avoid that conviction? Because even if you have to register, then you want to say, can I be found guilty of something lesser? So I, at some point, will get out of jail, at some point, will get out of prison. And I want to be able to say, how do you move forward? And so sometimes it's about saying, this is a bad space you're in. How do we get you past this, even though this is a big hurdle in front of it? That's what I'd be doing today.
And then I think from the victim's standpoint in this too, like if he were to get a lawyer, the family were to, get a lawyer. I mean, if you're a parent, you're probably furious, when horrified of this.
Right.
If you were defending the family, what's typically the approach that you see victims in these cases take?
No, it depends. I mean, it depends in a case like this. And I've seen this, and frankly, I have this going right now, where people do bring in lawyers, and sometimes the lawyers are involved. And they get involved in these kinds of cases. What happens when you get the complaining witness? And I say complaining witness because this person has not been convicted. We have a presumption of innocence here. We have to accept that. What I would say is, it depends. What does the complaining witness want? What happens if the complaining witness is a 17-year-old boy who said, I loved her. I still love her. And I'll be damned if I'm going to give anything to the court. They get nothing from me. You can subpoena me. I don't care. You going to charge me with a crime? You going to charge me with obstruction? Really? Me, the victim? Good luck with that. You may get that. And see, that can change the outcome of a case. Because now all of a sudden, you still have the burden of proof. You still have to establish this. And we haven't even dealt with whether or not all of that is admissible in terms of statements, in terms of text, et cetera, et cetera. So I think that's one question. But the other piece of this could help drive the prosecutor, if you're on the other side of this saying, I want this coach to go down, you could drive the prosecutors to not negotiate. You could drive the prosecutors to say, absolutely not. What we want is we want her prosecuted to the full extent of the law. We want her to do the guidelines. We don't want her to be treated any differently. You can get that. Now, that's over and above this question of civil liability, because
Right.
what you might see is somebody who's actually going to be suing not just her, but the Burnsville School District, because now you're talking about this broader question of, well, why would you hire somebody who molests children? So there's some exposure here, and I can guarantee that the city of Burnsville is meeting today, talking about, oh boy, what are we going to do here?
Yeah, you can't imagine for the superintendent, the principal, what a phone call that must have been like from police, giving them some of the details. Very early on in this case, certainly one that caught our attention, and we'll see how it plays out. Jack Rice, thank you for joining us here on Law and Crime. We appreciate it.
Always.
Reinhardt is next expected in court in Minnesota on August 6th. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.